Number 2, Ditech Financial versus Naidu.
Good afternoon, Your Honors. May it please the court, I'm Christina Lavorsi, and I'm appearing on behalf of the appellant.
Ms. Lavorsi, would you like to reserve some rebuttal time?
Yes, 3 minutes for rebuttal, Your Honor.
You may have 3 minutes.
Thank you. Given the similarities between our case and those that were set forth in Freedom Mortgage, namely that both actions involve a stipulation of discontinuance, I'm just going to take a few moments of the court's time just to expand upon a few of the arguments that were made by Freedom Mortgage in their case, and a few of the points that were raised by the court. I first wanted to advocate for the court accepting a bright line or creating a bright line rule here, that the timely filed stipulation of discontinuance, which was the case in our action, is sufficient to revoke or nullify, whichever language you would prefer to use, in and of itself without any further language having to be provided in the stipulation. And to answer the court's question earlier, I don't believe that because the stipulation itself doesn't expressly say that we hereby revoke, that it's silent on this issue. Albertina, this court in Albertina made very clear that the overt act was the filing of the summons and the complaint. And the converse of that, the overt act of revoking that acceleration would be the discontinuance here, which was a stipulation agreed to by respondent through counsel. It follows that this makes a clear rule for the parties to proceed going forward. The court had asked the question about whether or not, in addition to setting forth something in the stipulation or just filing the stipulation, why wouldn't the lender also provide a letter or some other notice expressly stating that the acceleration had been revoked? And the problem with that approach, and I think Mr. Sutherland touched upon that, is that this doesn't create a clear rule. I think it's going to provide more litigation. It's going to be a morass. Was the letter itself, what was provided in the letter, sufficient to put the borrower on notice? Was the letter actually received by the borrower? We're going to have disputes
Judge,
over.
can I ask a question here?
Yes, Judge Fahey.
Good afternoon. The Albertina question, it's a 1932 Court of Appeals case. And in the midst of the Great Depression, they said that you need an unequivocal overt act to accelerate the debt. We agree on that, right?
Yes.
Okay. So why don't you need an unequivocal overt act to decelerate the debt?
I think that's what you have with the stipulation of discontinuance, and I think it meets the Albertina requirement.
Let me stop you there. An unequivocal overt act, the way I understand the English language, is that's something that lays out clearly what you're doing. One accelerates, the other decelerates. So if it's good for the goose to require acceleration, why isn't it good for the gander to require an unequivocal overt act to decelerate?
Right. And going back to your point, I think the term overt, as it's being talked about in Albertina, talks about something that's open and observable. Mm-hmm. And by the filing, Albertina was talking about giving constructive notice to the parties by the filing of the summons and the complaint. And I think the same thing happens here by the converse taking place. Yeah,
but come on. I mean, overt is overt. You say it to the person. You say, this is the deal. You know, when we're doing this, we got to do it unequivocally and overt. When we're accelerating debt, we got to tell you we're accelerating the debt. So when we're decelerating the debt, why shouldn't we have to tell you we're decelerating the debt? Because you can accelerate the amount of money I got to pay you, but I don't have to tell you that I'm decelerating it. And forget about your contextual analysis, whether it's for service reasons or the statute of limitations, if you have the legal right to do that, you should be able to do that. The only question is, why shouldn't you just have to tell the party? If you got to tell them to do it, why don't you tell them when you're not doing it?
Because I think it's automatically implied. And I agree with Mr. Sutherland that at this point in time, and when
So
our
you're saying that this
stipulation,
isn't so I'm clear, you're saying that this is an implicit rule?
I do. I believe that it is, even if it's not expressly stated, by the very nature of what a stipulation of discontinuance does, as talked about in Loeb v. Willis, it goes back and it annuls what has occurred in the proceeding. And the proceeding encompasses the commencement of the action, which is the act of accelerating the debt.
Thank you.
Certainly.
Judge, can I ask a question about
Judge
that?
Stein.
So, are you saying that, as I read Albertina, it clearly didn't require specific notice to the borrower, because it said that the acceleration was effective upon the filing of the complaint. And back in those days, the borrower didn't get notice until it was served. And so are you saying that there is a difference between an equivocal overt act and actual notice? Is that what you're trying to say?
I do. I think that Albertina was talking more in the context of a constructive notice. They talk about the second sentence after the discussion about an unequivocal overt act talks about that it disclosed the choice of the plaintiff and constituted notice to everyone. And while I understand that maybe notice wasn't actually given because it was a commencement by service, the filing actually constituted constructive notice. And typically there would have been a lease pendants also filed, which would have put everybody on notice as well. So it's more of a constructive notice.
I'm also a little bit concerned about your argument that that under Loeb, everything is annulled, including the revocation, because I'm not really sure what other implications that might have for other, who knows, statutes, contracts, whatever. And I mean, would you agree that it doesn't need to annul it? It just needs to revoke it?
Yes, at a minimum, it revokes it. And I would agree with that. And I think in the end, it comes out to the same end. It reverts everything back to an installment contract where you can collect on each installment due and owing. And I think that lends to, it contradicts what the court was suggesting, where maybe the lenders might be manipulating the statute of limitations, because that concept that we're going to be manipulating the statute of limitations really writes out of the contract the fact that it's an installment contract and there's still a statute of limitations period, even if the statute of limitations period isn't running from an accelerated debt. You're still going to be losing installment payments. It doesn't behoove the lenders to delay in any sort of way.
Thank you, Ms. Lavorsi. Counsel?
Thank you.
Counsel?
Am I there? Okay.
Yes.
May it please the court, I'm Holly Meyer representing the respondent in this matter. There's two major issues here, and the court's been addressing this for a little while now. The number one is the nullification. The concept is that the acceleration only occurred because we filed the complaint. That actually goes directly against our whole concept of filing suits. This court even stated that in order to have a cause of action, the cause of action creates the right to sue. And when the cause of action has to have all the material elements and facts have to have occurred in order to trigger that cause of action. That must occur prior to the right to suit. And then the right to suit, you then go ahead and file your complaint. In the situation of what is the evidence of their intent to accelerate can easily found when they drafted and executed the complaint that specifically said that there was an acceleration and the amount now due was the unpaid principal balance. And I would note that the complaint was executed and affirmed by an attorney who affirmed the truthfulness of those facts. And that was executed on July 27th, 2009.
Chief Judge, may I ask a question?
Judge Stein?
Actually, I have two questions. Again, and I guess this is part of my theme here today, is I don't see where you made this argument in Supreme Court, but let's assume for the moment that you did. How would one know the moment in which the acceleration took place? The acceleration, according to Albertina, requires an unequivocal, overt act. Okay, so, you know, maybe you're right that something had to be thought about and decided before the complaint got filed, but it just, I think it seems to me that you would be really creating a very ambiguous rule about when that statute of limitations began to run.
Actually, you're looking for a definitive moment in time that you can say that evidences the time that they accelerated. Am I understanding the question correctly?
Well, yes, I think that you know, you can make certain assumptions, or you can look for that exact moment in time, and remember that the acceleration won't always be by commencing an action or by filing a complaint. There may be other ways of doing it. So, you know, we have to look at all of these. So I guess my question is what is your rule, your proposed rule in this regard?
Well, I did argue in the appellate division, I said that the overt act had to have come prior to the filing of the complaint, and we could directly go to the date that the complaint was executed as the facts being sworn to and affirmed. That's a definitive date that is acknowledging that the plaintiff has accelerated. It's right there in black and white. There is no ambiguity. There's no question. There's nothing. I would also note for the court that in the mortgage, it specifically states that the lender, if they accelerate and demand that and require I make immediate payment, they may bring an action. There is no requirement that they bring an action once they accelerate. They can make that demand, as we've seen in other cases. Demand can be made by notice. So the webbing the two and marrying the two together so firmly actually brings up the question, well, if acceleration doesn't occur until after you file suit, then how did you have the right to sue in the first place?
Chief, if I might try.
Yes.
I'm having a little trouble following your argument for the following reason.
Yes.
If your point is that ordinarily a cause of action accrues for statute of limitations purposes the moment you have a right to sue, then the first time there is a default and the other conditions in the mortgage are met, for, you know, there may be notice and cure provisions and so on. But once that's met, the cause of action on your theory begins to run even if the lender doesn't want to foreclose. And that 6 years starts running from that point when the cause of action accrued. I don't think that's the way that you know, foreclosure law has worked for centuries.
Well, we're talking, with all due respect, I think we're also talking about the statute of limitations and how many in other areas of law do we find personal injury, medical malpractice cases, many different cases where we say as soon as the cause of action accrues, if you don't.
Yeah, so what I'm really asking is, isn't the law different here because in a mortgage case, you have installment payments. And in essence, there is a new cause of action accruing every month that those payments are due. So you don't have where you would say, okay, the first time that there's a default that meets the terms of the mortgage, my 6-year statute of limitation starts running on a foreclosure remedy. Nobody says that. It isn't until there is some affirmative decision made that the law says you then start to run the statute of limitations. You could have had a cause of action 10 years ago and elected not to pursue it. And that, even though you have a cause of action in the medical malpractice area, in most other areas, yes, that starts your statute running. But in foreclosures, it doesn't. Isn't that right?
Well, in the foreclosures, as Your Honor said, you have the statute of limitations starts to run when payment is due. And when it is still under the installment agreement, each installment that is missed accrues another cause of action. The amount is due. When you're talking about an acceleration, you're talking about now when the entire amount is due. And that is made by the acceleration. And in order to have a cause, like you can't bring an action for an installment payment that's due in 2025 because it's not due yet. The same concept is utilized with my acceleration. If it has not been accelerated, it's not due. So therefore, you don't have the factual grounds for a cause of action or a right to sue. I'm not saying that they don't obtain the right to sue. Our position is it's not married. So the concept that because the complaint and the proceedings get nullified by the discontinuance does not mean the facts that gave rise to the cause of action are nullified. They don't get erased from history.
But the facts that gave rise to the cause of action are not what triggers the statute of limitations running. Isn't that right?
I apologize. I'm not understanding the question.
Sure. You might have facts that could give you a cause of action to sue once there's a default. You might choose not to accelerate and your statute of limitations hasn't yet started running.
Yes.
So it isn't the facts that gave rise to a cause of action and therefore, whether you nullify the facts or not doesn't make any difference to your argument.
Well, our position is that it's the acceleration or the choice to accelerate is the fact. And that choice is evidenced by some definitive act. And if we're looking for a point in time, the first point in time, all you have to do is turn to the time that the complaint was executed. And once you have that determination, you see that the filing of the complaint is not married to the time that there was an acceleration.
Chief, if I may.
Yes,
Sorry.
just come in.
So changing subjects for a moment.
Yes.
I was a little intrigued because I'm not sure I quite followed your argument that automatic revocation through discontinuance is somehow unfair to the lenders. And I didn't know if you could...
In that situation, I was talking about lenders who don't want deceleration. There are cases out there where a lender chooses to accelerate an installment agreement, and for whatever their choice, they don't want to revert back to the installment. They simply want to keep the acceleration.
Couldn't they then, if that's the case, expressly state that they are not revoking the acceleration?
But then you can't do it's not a bright line rule that it's an automatic, because then becomes a choice again. And what we're doing now is we're putting the burden on somebody, on a lender who has validly accelerated. Now they have to take the steps not to decelerate, instead of saying, well, if your intent is to decelerate, which we argue that there may not be, then that's a burden that shouldn't be there.
Judge, I have a question, if I may. So
Yes.
can you just work through this analysis for me? I'm just trying to make some sense of this. So you're a lender, you accelerate because there's been a default.
Yes.
You've called it all due.
Mm-hmm.
And then you've chosen not to proceed with the foreclosure, right? Discontinuance. You're saying that there might be lenders who nevertheless are still in the mode of acceleration.
Mm-hmm.
So they still want the full amount paid. Okay, so how, other than demanding it from a person who has been in default, hasn't paid, and things seem so dire that the lending institution went to court to try and get that full payment, I don't understand how they're in a difficult position, right? That you're saying they want to keep demanding that money, so don't they just go back to court demanding the money? What am I missing?
But there's a gap there. And all a borrower has to do is meet them on the courthouse steps and give them the payment. And before they get a chance to.
Well, the payment in full, correct? Because you're saying that's what they
an
demand.
installment payment, pay the arrears. And now that lender is back to an installment contract.
But can't they then just file, since it was decelerated to accelerate, they've got their installment, now they can accelerate? Are you saying that?
No, they've got their installments, so now it's not in default anymore and they lose their rights to accelerate. It's something that they.
Until the next default.
Excuse me?
Until the next default.
If there is, but I would also really quickly note that this stipulation is contrary to any intent to revoke, because the plaintiff who wrote it was BAC, and they specifically wrote that all claims of the plaintiff shall be dismissed without prejudice, meaning that all their claims would survive after the discontinuance. And the claim here was that they accelerated and they were entitled to the entire unpaid principal balance. So simply saying that because we entered in a stip, that there was no,
So Judge, if I may ask, so
Yeah.
I just want to understand, as I asked in the prior case, sort of the logical conclusion, the extension of this analysis. Does that mean, if we saw it your way, if we said, look, it's got to be expressed in that discontinuance, or there has to be some other express statement, let's just say it that way, and there isn't, does that mean that the debtor could go around paying in installments, keeping their eye on the clock, and then when they hit year 6, go into default and say, well, you can't demand any more money from me because you're time barred? What's fair in that?
well, that's a hypothetical that I unfortunately haven't been able to find. What I usually find is homeowners actually want to get back into the groove. But what happens is that a borrower might lose their job for 6 months. They get back into work. They want to go ahead and start making payments again, but now they can't because they don't have 6 months worth of payments. And then it takes another 2 years if they get a modification. And now we're 2 years down the line with payment penalties and interests and everything else. And they're the ones that are behind the 8 ball, where all they wanted to do in the first place was go ahead and pay their mortgage. We're not looking at something where a borrower sets out to get something for free. What they're setting out to do is have a home. The consequences of the inaction by a lender in waiting 6 years. In this case, the lender who commenced the action waited 5 years without even filing an RJI and then sought discontinuance. I reviewed the statute of limitations, knowing that my client, there was no stipulation in there about the revocation, and we agreed to give up his whatever good position he may have had to litigate the case. We said, no, we won't, but understanding that the statute of limitations is running, the bank will work with us. They either are going to come back and we're going to litigate it again within the next year, or the bank's going to come to us and they're going to work with us. That was the understanding, that the acceleration still was in play.
So if I'm understanding your view then, or your way of approaching this issue, is that means there's 6 years for both sides, so that the debtor is not going to end up getting any better, more time in this. Is that correct? If there's silence on this question of deceleration, so as you said, and as I said, the clock is ticking.
Yes.
And so the lender might say, well, you know, I'm getting pretty close to those 6 years. I know you keep saying you're going to try and pay, you're trying to pay, you're going through hard times, but I can't risk it. We're done.
And yes, I do agree that it should be on both sides. That's the contract.
Thank you, counsel. Counsel?
Thank you. I just wanted to touch upon a few points very briefly. Judge Stein, you asked the question about how would we know what the time was of the acceleration when the debt was accelerated, if it's stemming from something other than the filing of the complaint. And you wouldn't know. It creates perverse situations. We're taking a look at a filed complaint and then looking at the date of the signing. But what if you start digging through a file and there's a complaint that was signed, but the lender decided not to move forward with the foreclosure action? Or I think you're getting into a morass of potential pitfalls and litigation if there is not a bright line rule. And that bright line rule was expressly set forth in Albertina. An unsigned complaint or a verified complaint that wasn't filed doesn't give constructive notice to anybody, as envisioned by Albertina. The other part that I wanted to touch upon.
Judge, if I may ask, just to follow up on what this
Yes,
was
Judge
said.
Rivera.
So but you're not taking the position, counsel, that a lending institution could accelerate in advance of filing. Right? You can send a letter demanding and saying, I am accelerating with this letter.
Yes, if it complies, yes, you could certainly accelerate in other ways. I think commencement is just one of the ways in which you
So
could
if a lender does that, do they then have to put in writing, if they haven't filed, they come to some agreement with the debtor, do they then have to put something in writing saying we've decelerated? We've come to an agreement, we've decelerated. Do they have to do that?
Are you suggesting if you accelerated by some other mechanism than the commencement of an action?
Correct.
So I think that for all intents and purposes, the stipulation of discontinuance would still apply. Maybe it would be more clear if you've accelerated by a notice of default that you de-accelerate by some letter saying, we no longer are accelerating by way of our notice of default or the letter that we had sent you. But that's not our situation here in our case. And in our case, we had the stipulation of discontinuance. There's no notice of default. Even
Let me ask you this. If you don't do that, if you don't put it in some express writing, right? But the debtor keeps paying installment payments and you accept them, is that then the equivalent of decelerating?
I'm not sure it would necessarily be a deceleration, but it would be some sort of an acknowledgement of the debt, in my view, that they're continuing to pay on the loan. So it would extend the statute of limitations period in that regard.
Thank you, counsel.
Thank you.